Okay, so when it comes to jurisdiction in matters of parental responsibility, the new regulation does not alter the structure of the regulation now in force. So the Brussels IIb that we all know, the structure is mainly the same. And we have some adjustments in some provisions that were existing also in the Brussels IIb regulation. So we have some old problems and some new problems because of the new drafting of the provisions. So I will focus on 4 points. I will try to be very short on each of them. So habitual residence of the child, the new provision on choice of court, the specific ground of jurisdiction based on the presence of the child and its relation with the 1996 Hague Convention, and then the surviving residual jurisdiction provision in the new regulation. So let's start from Article 7, general jurisdiction. Article 7 was now, in Article 7, a new paragraph was now added. So paragraph 2, and paragraph 2 says that the general rule on jurisdiction is subject to Articles 8 to 10 of the regulation. Well, this drafting of the provision is in some way unusual or unexpected for me because it seems to point to a new hierarchy. We all know that the Court of Justice underlined many times that habitual residence of the child is the general rule, the general forum in the Brussels II system. Well, I would just like to point out that the word subject to Article 8 to 10 is possibly not the drafting of the provision that is more in line with the many rulings of the Court of Justice, because it seems to suggest that there is room for a different method of interpretation. As we know, the Court of Justice clarified that current Article 8 of the Brussels IIb regulation is, as a general rule, to be interpreted in broad terms. So other jurisdictional rules in the Brussels IIb regulation are considered as subject to strict interpretation. So I wonder, and obviously this is something that I put for the discussion. I wonder whether the new paragraph in Article 7 of the new regulation is pointing to a new hierarchy. A second point about Article 7, habitual residence of the child is a concept that raised several requests for a preliminary ruling. The notion of habitual residence of the child seems to be in some way obscure or not clear to domestic courts. Even though I have to say that some months ago I was involved in a project, and we had the occasion to discuss with Italian judges this problem of the habitual residence of the child, and they consider that this concept is very clear, and there is no need to discuss it so much. So it comes to my mind that the reason for so many requests for a preliminary ruling to the Court of Justice may be explained not by the lack of clarity of the notion of habitual residence of the child, or by the difficulties of domestic courts in determining the habitual residence of the child. Possibly, domestic courts are not really convinced by this idea of the proximity principle as a factor of certainty and as a factor that is connected to the best interests of the child, because the regulation is very clear on this point. Proximity contributes to the best interests of the child. However, it is possible that domestic courts are not really convinced, as some recent cases seem to show. So, for example, you have a list of cases in this slide, and so domestic courts were confronted with very different situation. In the case C 499/15, there was a previous judgment already adopted in a member state that was not anymore the country of the habitual residence of the child. And so the domestic court requested the Court of Justice to, if some kind of perpetuatio jurisdictionis was possible. The second case was already discussed yesterday, so possibly I can skip it. I will just mention that here the intention to settle in a different member state was at stake. And especially interesting in my opinion, is the third case. In the case C 393/18, the domestic court, that was a British court, was confronted with the action brought by a mother who claimed that she was forced by her husband to go to a third country and to give birth to her child in that third country. And so she was claiming that the habitual residence of the child was in fact the United Kingdom, where the child had never been in his life. So possibly the new regulation could have dealt with those suggestions from domestic court, and so I will just ask a question more than provide an answer. So is it possible that there is a need for some kind of clause échappatoire in Article 7 or about general jurisdiction? So the possibility to consider that the most closely connected member state is not, in some exceptional cases, the country of the habitual residence of the child, but a different country. Second point, Article 10, choice of court. Also, Thalia mentioned that Article 10 underwent some simplification if compared with current Article 12 of the Brussels IIb regulation. And certainly it is good to have now a rule on party autonomy that can be actually used, because if you have, as Article 12 sometimes proves to be a rule on Article 12 of the current regulation, that is not practically applicable, well, you don't have party autonomy. So Article 10 has certainly some better features than current Article 12. First, it is a quite simpler provision, and second, it enshrines a broader notion of substantial connection. So it enlarges the chances to have a choice of court. However, some points are still well, subject to a further revision or possible further revision. First, the requirement of compatibility with the best interests of the child. Here, I do not expect that the legislator will introduce any amelioraments, but I hope that the Court of Justice will go some farther than in the Saponaro case that was also mentioned by Laura, because we cannot consider as sufficient that compatibility with the best interests of the child is something that does not prejudge the best interests of the child. So we have to find some kind of test that is more useful for practitioners. Another point is that consent of all the holders of parental responsibility is still required for choice of court, at least in one of the two cases mentioned by Article 10. Well, probably this drafting is too broad. Oh, I'm sorry, is too broad. I just mention here that also grandparents are can be considered in some way as holders of parental responsibility because they have access right, as the court mentioned in Valceva. Article 11. Well, one can now wonder if Article 11 that is already in the Brussels IIb regulation and that provides for a ground of subsidiary jurisdiction to be activated when habitual resident cannot be determined. Well, one can wonder whether Article 11 could not have undergone some revision, and this from two different points of view. First, there is no coordination with EU acts in migration and asylum matters. So the Article 11 still refers to refugee children and to internationally displaced children. But what about the other situations that are dealt with in EU measures in migration and asylum matters? So, for example, asylum seekers or children that may have right to temporary protection. So this is something that could have been done, that could have been done, but well, the regulation didn't the new regulation does not deal with this. And well, there is a second point. If you read Article 11 in combination with Recital 25 of the regulation, you can figure out that there is a clear priority of the 1996 Hague Convention. So recital 25 mentions that Article 11 is going to apply only when the habitual residence of the child was before in a different member state. But, well, I really hope, and it is not something that can be foreseen today, that there will not be refugee children or internationally displaced children coming from a member state of the European Union. So one can wonder whether Article 11 will ever apply. Article 14, I see that my time is going to expire very quickly. So residual jurisdiction is still there. So the system of jurisdictional competence under the regulation is not self-sufficient. We still need domestic grounds of jurisdictional competence, possibly because we want a broad scope of jurisdiction for domestic courts. However, this means that we do not have inside the European Union private international law a uniform model for family matters, because other regulations in family matters, so the maintenance regulation and also the twin regulations concerning registered couples and property regimes between spouses have no residual jurisdiction. And also another question that I would like to ask is if forum of necessity is really necessary, because if it is not necessary in parental responsibility matters, so when the most vulnerable individuals are the very subject of the proceedings, well, I have some doubts that it can be necessary in other matters. So my conclusions, a very provisional assessment, rules on jurisdiction were considered as ensuring a smooth functioning of the system. And so the motto was quieta non movere. So this suggestion was taken seriously by the legislator that decided to not to introduce general changes, but only small adjustments. Probably some good adjustments, but other amendments could have been useful. And so probably my conclusion is that, well, when I think of a recast, I think of something that is a general revision of the instrument, and that tries to touch upon every relevant point. But possibly the conclusion is with Gertrude Stein that a recast is a recast is a recast. Thank you for your attention.